Have you ever found yourself just, staring down a mountain of information, maybe complex legal documents, or maybe just a crazy long outline for a huge exam, and you just get that feeling, where do I even start?
Oh, yeah. Information overload, it's real.
Especially when it's something as high stakes as the bar exam,
Yeah.
right? That feeling could be, well, pretty daunting. You almost wish there was a shortcut, a direct path to the really important stuff explained in a way that actually sinks in.
Definitely. A way to cut through the noise.
Well, you're definitely in the right place today. We're taking a deep dive into an area of law that honestly affects everyone, sometimes in really surprising ways. Wills.
Mm.
And this isn't just about, dusty old papers. It's about how people's final wishes get honored. Or, maybe just as important, how the law steps in when those wishes aren't clear.
Right. The default plan.
Exactly. And for you, our listener, this deep dive is really custom tailored. Our goal isn't just to give you a solid understanding of Will's law, but also like a strategic toolkit, something to help you absolutely nail those essay questions on the bar.
That's precisely it. Our source today is this really comprehensive review outline. It's got all the core principles of Will's law packed in there. But like you said, we're not just going to read it to you.
No way.
Our mission here is to slice through that complexity, pull out the most critical nuggets of knowledge, point out some genuinely surprising facts, and maybe most importantly for you, give you a framework.
A framework. I like that.
Yeah. It's not just about understanding the law abstractly. It's about applying it. Specifically, how you can approach, break down, and structure a Will's essay question so you're showing not just what you know, but how you think like a lawyer needs to think.
That's the key difference, isn't it? By the time we wrap this up, you'll have a clear handle on the fundamental principles of wills. You'll get the common traps, those subtle but really vital distinctions between different legal rules.
Like UPC versus common law.
Exactly. And how to structure your thoughts for an essay. You'll be ready to hit those hypotheticals with confidence, knowing exactly where to begin and what points to cover.
And just to add to that, this isn't only about memorizing rules, it's really about developing a systematic way to analyze complex facts, which, as you know from all your studying, is the absolute key to success on the bar and, honestly, in your whole legal career. Let's make this deep dive a really valuable study session for you.
Okay, let's dive in. Our first big section tackles what happens when someone dies without a will. Or maybe they have one, but it doesn't cover everything. It's called intestacy, the default plan when there's no will. So what exactly is intestacy and why is this the absolute starting point for us, especially thinking about the bar?
Right. Intestacy is basically the law's backup plan. It's the statutory distribution scheme, the set of rules that kicks in when a person, the decedent, dies without effectively getting rid of all their property through something like a trust or, a valid will.
So it's the default.
It's the default.
Yeah.
And the people who inherit under these rules, they're called the decedent's heirs.
Okay, so if I say don't have a will, or maybe my will only mentions my house but not my bank accounts, the state just steps in and dictates how everything else gets divided up. Is that it?
You've got it. The law fills the vacuum. It provides a preset framework so property doesn't just sit there in limbo. And for your essays, this is often the very first thing you need to consider.
First thing. Got it.
If the problem gives you a situation with no will, or a will that doesn't cover everything, boom. You start your analysis by applying the rules of intestacy to whatever property isn't handled otherwise. It's step one on your essay roadmap.
And when we talk about who inherits, that family tree idea is pretty important, legally speaking. Our source has a good who's who breakdown. Can you walk us through those key relationship categories for figuring out inheritance lines?
Absolutely. It helps structure your thinking. You're mainly looking at three groups. First, issue or descendants. That's all your lineal descendants. Children, grandchildren, great-grandchildren, straight down the line.
Down the tree.
Right. Second, ancestors. Those are your lineal ascendants. Parents, grandparents, great-grandparents moving straight up the tree.
Up the tree. Makes sense.
And finally, collaterals. These are relatives who aren't direct descendants or ancestors. Think side branches. Siblings, nieces, nephews, aunts, uncles, cousins. Understanding these categories is fundamental. It's how you trace who might possibly take under intestacy. Often your first step in identifying potential heirs in an essay, the surviving spouse's share.
Now, one of the biggest shares in intestacy, and probably a frequent point of conflict, goes to the surviving spouse. Our source really flags a key distinction here between the Uniform Probate Code, the UPC, and more traditional state laws. What's the main thing we need to remember for exam purposes?
This is super critical, and yeah, they love testing this because it forces you to compare different legal approaches. The absolute bottom line is this. The
Mhm.
UPC is generally way more generous to surviving spouses than older state laws.
Way more generous.
Yeah. It's not just a little tweak. It reflects a whole shift in how modern law views marriage as a partnership. So when you see a surviving spouse in an essay question, your first thought should be, is this a UPC state or a traditional one? Because the answer can make a huge difference to what that spouse gets. Could be everything, could be much less.
That's a massive difference right there. And the UPC gets really specific, doesn't it? Even down to dollar amounts in different scenarios. Can you lay out those main UPC situations for a spouse's inheritance?
Sure. Under the UPC, the surviving spouse gets the entire estate in two very clear situations. First, if all the decedent's descendants are also the surviving spouse's descendants, like no kids from previous relationships on either side, and the spouse doesn't have other kids from a previous relationship.
It is simple family structure.
Right. The second situation for the whole estate is if the decedent has no surviving parents or descendants at all. Basically, if it's just the spouse left in the immediate picture. In those cases, spouse takes all.
So, shared family unit or no one else directly in line spouse gets everything. Got it.
Mm-hmm.
What about the trickier scenarios where there are other relatives involved?
Then the share gets sliced up a bit, but the spouse still usually gets a very large piece. The spouse gets $300,000 plus 75% of whatever's left if the decedent has no descendants but does have a surviving parent. So the parent gets something, but the spouse gets the lion's share.
Okay.
Now, if all the decedent's kids are also the spouse's kids, but the spouse has other kids from a prior relationship, stepkids to the decedent, basically then the spouse gets $225,000 plus half of the rest.
Yes, okay.
And the last one, maybe the most complex. The spouse gets $150,000 plus half of the remainder if the decedent has kids not related to the surviving spouse. So kids from the decedent's prior relationship.
The decedent's kids from before.
Right. The key thing to remember, regardless of memorizing the exact numbers for the exam, is the UPC's philosophy. Consistently secure the surviving spouse financially first.
The numbers are specific, but yeah, the pattern is clear. Protect the spouse. Now, how does community property fit in? Because that's a whole different system, right?
Oh, absolutely different. And you have to deal with community property first if it applies in your fact pattern. It's a distinct legal framework in some states. The core idea is that property acquired during the marriage is jointly owned 50-50.
Unless it was a gift or inheritance just to one spouse.
Exactly. Those are exceptions. It's separate property. So if the decedent dies without a will in a community property state, their 50% share of the community property automatically goes to the surviving spouse, period. Any separate property the decedent owned. That then follows the state's general intestacy rules or goes by will if there is one. So, community property rules determine what even makes it into the intestacy pot in the first place. Survival requirements for heirs.
Speaking of survival, what about the rule that an heir actually has to, survive the decedent to inherit? Seems obvious, but I bet there are wrinkles, especially if deaths happen close together.
You're right, it's not always simple. An heir, whether under a will or intestacy, definitely has to survive the decedent. And this is where you see a big split between old common law and the widely adopted Uniform Simultaneous Death Act, the USDA.
Okay, common law versus USDA.
Under common law, you just had to survive by any length of time, even a minute. If you outlived the decedent briefly, you inherited. The USDA, much stricter. It imposes a 120-hour survival requirement, 5 days.
Oh, 5 days, wow.
Yeah. If you can't prove with sufficient evidence that one person survived the other by 120 hours, then each person's property passes as if the other person died first. This avoids property passing through one estate only to immediately go into another, which gets messy with multiple probates.
And how do we even define death nowadays? I know that's changed. And who has to prove this survivorship, especially if it's murky?
Historically, yeah, it was about heart stopping, breathing stopping, circulatory and respiratory functions. The modern standard now often includes brain death, although our source notes there isn't always universal agreement on the exact criteria. As for who proves it, the burden of proof always falls on the person whose claim depends on proving survivorship. Under common law, you just need a preponderance of the evidence more likely than not. But under the USDA, because that 120-hour rule sets a higher bar, the standard of proof is also higher. Clear and convincing evidence is required. That's a big difference in court. Identifying issue, lineal descendants.
Moving down the line from the spouse, let's talk more about issue, the lineal descendants. What's the precise legal definition for inheritance, and what are some common tricky spots here?
Right. Issue means all lineal descendants, children, grandchildren, great-grandchildren, etc., tracing straight down. But importantly, it specifically excludes descendants of living lineal descendants.
Ah, okay. Explain that.
So if your child is alive, their children, your grandchildren generally aren't counted as issue for the first split of your estate among your children. Your living child takes their share. The grandkids would only step into their parent shoes if that parent had died before you. So the division usually happens at the closest generation to you where there's someone still living.
That makes sense. My grandkids don't get a direct slice unless their parent, my child, is already gone. What about kids born to married folks? Pretty strong presumption there, right?
Yes, very strong. There's a widely accepted rebuttable presumption that a child born to married parents is the natural child of that marriage. This even extends to posthumously born children. If a child is born within 280 days after the husband's death, they're presumed to be his child.
Okay, born within about 9 months after death.
Right. But, and this is a classic bar exam trap, a posthumously conceived child, conceived after the parent's death, maybe using frozen genetic material, is generally not recognized as a child of the deceased for inheritance.
Big difference. Conceived after death.
Huge difference. It prevents claims popping up years later on an estate from children conceived long after the parent passed. Born after versus conceived after is critical.
Absolutely vital distinction. What about adopted kids? How do they fit in?
Yeah.
Treated just like biological children.
Generally, yes. For inheritance, an adopted child is legally treated as a biological child of the adoptive parents. They inherit from their adoptive parents. But this usually means the inheritance link with their genetic parents is severed. The adoption creates a new legal parent-child line and cuts off the old one for inheritance.
But there's that specific step-parent exception, isn't there? Sounds like prime testing material.
It is, and it's a key exception. When a step-parent adopts a child, yes, it creates a full parent-child relationship with inheritance rights between them. But here's the crucial part. It doesn't cut off the relationship between the child and the genetic parent who's married to the step-parent.
Okay, the connection to the parent still married to the step-parent remains.
Right. And it also doesn't stop the child from inheriting from or through the other genetic parent, the one not married to the step-parent. So the child can potentially inherit from the adopting step-parent, the genetic parent married to the step-parent, and the other genetic parent's family. It preserves those ties.
And then there's this interesting sort of fairness-based idea, equitable adoption. What's that about, and what are its limits?
Equitable adoption isn't a formal legal adoption. It's an equitable remedy. It's where foster parents or step-parents who didn't formally adopt might still be treated as adoptive parents for inheritance purposes.
How does that act?
Two main ways. Either the relationship started when the child was young and there's clear evidence a legal barrier stopped a formal adoption and the foster parent treated the child as their own, or there was an agreement with the genetic parents to adopt, and the foster parent consistently treated the child as their own. It recognizes a real parent-child bond.
But there are limits.
Big limits. The child can inherit from the equitable parent, but not through them, like from the equitable grandparent. And importantly, the equitable parents cannot inherit from or through the child. Plus, the child's rights with their genetic parents remain intact. It's basically a one-way street benefiting the child.
So it helps the child inherit from a de facto parent, but doesn't create full reciprocal rights or cut other ties. What about half-bloods relatives sharing only one parent?
Thankfully, the majority rule here is simple. Half-bloods are treated exactly the same as whole-blooded relatives for inheritance. Your half-sibling inherits just like your full sibling, no difference.
And kids born outside of marriage, how do they inherit from their biological father nowadays compared to older, stricter rules?
The modern trend allows children born out of wedlock to inherit from their biological father, but it's not automatic. You need proof of the relationship.
What kind of proof?
Several ways. If the father later married the mother, if he openly held the child out as his own and lived with them or provided support, if paternity is proven by clear and convincing evidence after his death, or if paternity was legally established during his lifetime by a preponderance of the evidence, it's about showing that legal or factual acknowledgement.
So a clear connection needs to be established, and the Uniform Parentage Act adds a time limit sometimes.
Yes, the UPA is important here. If a father openly acknowledged the child holding out, there's a presumption of paternity, and the child can sue to establish paternity basically any time. But if there was no holding out, no open acknowledgement, then there's no presumption. In that case, the child usually has to bring an action to establish paternity for inheritance within 3 years of turning 18. So that deadline can be crucial in an essay scenario. Calculating and intestate share the methods.
All right, we've figured out who might be an heir. Now, the million-dollar question, how do we actually calculate their share? The source outlines 3 different methods, and you stressed how vital these are for essays.
Absolutely vital. You have to know how these work to calculate distributions and hypotheticals. They represent different ways of slicing the pie among descendants. The main 3 are per capita with representation, per stirpes, and per capita at each generation.
Let's break them down. First, per capita with representation. How's that work?
Okay, per capita with representation. You go down the family tree to the first generation where there's at least one living member. You divide the estate into equal shares at that level.
First level with someone alive.
Right. Then, any shares for members of that generation who already died. Those shares pass down to their living issue, their kids or grandkids, etc. If a deceased member at that first level has no living issue, their share just disappears, doesn't get redistributed at that level. The initial cut happens higher up, then drops down.
Okay, cut at the first living layer, then drops down if needed. What about per stirpes? That term rings a bell for many people.
Per stupus is the older method, sometimes called by the roots. Here, the division always starts at the generation of the decedent's children, regardless of whether any children are actually alive.
Always starts with the kid's generation.
Yes. You divide the estate based on the total number of children who either survived the decedent or who died before but left surviving issue. Each deceased child's share then drops down to their respective family line to be divided among their descendants. This can lead to cousins getting unequal shares if different branches have different numbers of kids.
And then the one that sounds the trickiest, per capita at each generation. How do we wrap our heads around that one?
This method aims for maximum equality among relatives at the same generation level. Here's the process. You start like per capita with representation, find the nearest generation with living members, and divide the shares. Count the living members and the deceased members who left living issue.
Okay, same starting point.
But here's the key difference. After you allocate shares to the living members at that first level, you take all the remaining shares, the ones for the deceased members, and you pool them back together.
Pull the back. Okay.
Then, you divide that pooled amount equally among all the members of the next generation who are eligible, e.g., all the grandchildren, regardless of which child they came from. Everyone at that grandchild level gets the same size slice from that repooled amount. It's the most equitable for cousins.
The repooling makes a difference. That clarifies it. A practical tip for essays.
Start like per capita with representation. Identify that first generation. But then combine the leftover shares and divide them equally at the next level down. Repeat if necessary.
Got it. And quickly, under intestacy, can you intentionally leave someone out? What's negative inheritance?
Yes, this is allowed under the UPC. An individual can explicitly disinherit an heir, stop them from getting an intestate share, but it has to be done in a properly executed will. The will needs to clearly state the intent to disinherit that specific person. Without that clear statement and a valid will, the regular intestacy rules apply, even if you told everyone you didn't want Bob to inherit.
And what if there's no spouse or issue at all? Who's next in line?
Then we go up and sideways. If no surviving spouse or direct descendants, the property goes up to ancestors, usually parents first. If no parents, then grandparents.
Okay, up the tree.
Right. If no ancestors are alive, then it goes out to collateral relatives, siblings, niece-nephews, aunts, uncles, cousins. There are different systems for tracing this, like the parentelic approach, UPC uses this, follows collateral lines carefully, or the degree of relationship approach, counts steps on the family tree. The key for your essay is just knowing this fallback exists when the immediate family is gone.
Okay, that covers intestacy, the default rules. But what if someone did make a will? That brings us to our next big section, execution of wills making a will valid. This is all about the nuts and bolts, the legal formalities. What are the absolute must-haves for a will to be legally sound?
This is totally fundamental for any will contest or validity question you'll face. There are 3 core elements, and you need to be able to check each box. First, it has to be in writing. Second, it must be signed by the testator, the person making the will. And third, it needs to be witnessed by 2 or more witnesses.
Writing, signature, 2 witnesses.
And woven through all of that, there must be present testamentary intent. The testator has to mean for this document to be their will right now. Now, common law used to demand strict compliance with these rules. Any tiny slip-up could kill the will. Modern law, especially the UPC, is often more flexible.
Let's unpack those. First, the writing signed by the testator. What's important there? Typed okay, handwritten. What counts as a signature?
The whole will has to be in writing. No videos or audio recordings generally count. Typed is perfectly fine. If it's entirely handwritten, it might qualify as a special type called a holographic will, which we'll get to. The testator has to sign it, or someone can sign for them if it's in the testator's presence and at their direction.
That signature itself.
It doesn't have to be their full name. Even an X can work if they intend it as their signature to make the will effective. Now, where they sign matters in some places. Some states demand the signature be at the very end. Others, including the UPC, allow it anywhere. But be careful, any text after the signature might be ignored or invalid. So, best practice. Sign at the bottom.
Good tip sign at the end to be safe. What about the testator's mental state? Testamentary capacity. This sounds like a major area for challenges.
Oh, absolutely crucial, especially in will contests. The testator has to be 18 or older and, critically, of sound mind.
Yeah.
Everyone's presumed to have capacity, so the burden is on the challenger to prove they didn't.
And what does sound mind mean here? What do they need to know?
At the moment they sign the will, they need to understand 4 key things. 1, the nature and extent of their property, basically what they own. 2, the natural objects of their bounty, who their close family and loved ones are, the people they'd normally think about providing for.
Okay. Property, people.
3, the disposition they're actually making, who gets what in the will. And 4, how all these pieces fit together in their overall plan. If a challenger proves the testator lacked any of these 4 understandings when signing, the will fails for lack of capacity. It's a big hurdle.
Makes sense. Understanding the whole picture of what they're doing. Next up, 2 or more witnesses. What are the rules about them being present during the signing? This sounds like another area with different rules.
It is, and a common testing point. The majority rule, reflecting older common law, is pretty formal. The testator must sign or acknowledge the will in the presence of both witnesses, present at the same time, and then the witnesses must sign in the presence of the testator.
Everyone in the room together, basically.
Pretty much, but the UPC rule is way more relaxed. Witnesses don't have to sign in front of the testator or each other. They just need to sign within a reasonable time after watching the testator sign, or after the testator acknowledges their signature to them. Much easier logistically. Definitely note that UPC flexibility for essays comparing rules.
So UPC loosens that up significantly. And there are specific tests for presence itself, right? Line of sight versus conscious presence.
That's right. The line of sight test is the traditional literal one. Testator and witnesses must be able to physically see each other sign, or at least have the opportunity to see, direct line of sight.
Okay.
The conscious presence test is more modern, broader. The person observing the signing just needs to be aware it's happening through their senses, even if they can't see it directly. They know it's being done. This test is often used if someone signs on the testator's behalf, a proxy signature. It focuses on awareness.
And what about interested witnesses?
Yeah.
People who actually get something in the will. Sounds like a potential problem, a conflict of interest.
It absolutely can be, and the rules here have really evolved, making it a prime testing area. At old common law, if a witness was getting a gift, they weren't considered competent. If there weren't 2 other disinterested witnesses, the entire will could be invalid.
Wow, the whole will.
Yeah, very harsh. The majority rule today, the purge theory, is softer. The will itself might still be valid, but the gift to the interested witness gets purged, invalidated to the extent it exceeds what they would have gotten without the will, like via intestacy.
So they lose the extra benefit.
Right. But the UPC, it goes all the way. It completely abolished the interested witness doctrine. An interested witness signing a will in a UPC state, no problem. They get their full gift. So depending on the state, an interested witness could invalidate the will, lose their gift, or face no consequences at all. Huge difference.
Massive difference. Really makes you focus on the jurisdiction. Okay, last element. Present testamentary intent. What does that boil down to?
It means right then, at the moment of signing, the testator must understand they are executing a will, and they must intend for that specific document to be their final word on distributing their property after death. They need to generally know what it says and approve its purpose, even if they don't grasp every single legal term. The key is they intend this paper to be their will. Integration and compliance.
So it's about the document's purpose, not necessarily every fine detail.
Mm-hmm.
Okay, related concepts. Integration and compliance. What's integration?
Integration just means figuring out which pieces of paper actually make up the will. A will consists of all pages that were physically present when it was signed and that the testator intended to be part of that single document. Helps make sure no pages were swapped in or out later.
And compliance. We touched on strict versus substantial earlier with the formalities. Can you expand on that difference?
Yeah. Common law, as we said, demanded strict compliance. Miss one little step in the signing ceremony. Will's invalid, very rigid. The UPC in some states now use a more